that was the historic judgment pronounced by the Supreme Court of India on the issue of marriage equality. The Supreme Court has refused to recognize marriage equality under the present and the existing legal framework, an impossibility of sorts, legally speaking, that the court argues. In principle, in notion, as a virtue, the court recognizes that the LGBTQIA community has the right to form associations. And in fact, the Chief Justice of India, along with one other judge, agreed to the point that there should be some form of civil partnerships that should be recognized. But here are the key takeaways from that major judgment that was a red letter day, keeping in mind that civil rights and marriage equality is something that the community has been demanding. Number one, right to marry is not a fundamental right. That means just because the Special Marriage Act, personal laws or any other statutory scheme in some way keeps the homosexual couples out of the present legislative framework, it doesn't make the law void. Marriage is not a fundamental right. Secondly, the Special Marriage Act is not void, which means that just because the definition of marriage is heterosexual in nature, the gender assumptions are there, it doesn't mean that those particular sections are bad in law. And the third one, the court is very conscious of the view that they cannot step into the domain of the legislature and words cannot be read into the Special Marriage Act. All 5 judges on the bench agree that marriage is not a fundamental right. We can't put it mildly, but this is not something that the petitioners wanted. They wanted much more to come from the Supreme Court of India. Ananya with us on the broadcast. Ananya, any reactions that you're getting from the Supreme Court? We'll try and connect with Ananya Bhatnagar. Those were the hearings that you were having a look at, the live streaming of the proceedings. Let's cut across to some reactions coming in from the Supreme Court lawns.
I welcome the decision of Honorable Supreme Court in which they have not permitted the same-sex marriage. Some people try to spoil the atmosphere of Indian system. But I am happy that Supreme Court of India has accepted the version of the Government of India in which it was argued that the court has no power to give this right of same-sex marriage. It is the only right of the Indian Parliament. Today it has been accepted by Honorable Supreme Court, and we are happy that Supreme Court has held that this power can't be given to same sex for having the marriage because India is an ancient country. Indian population is having its values in society. So by not providing this right, we hail the judgment of Supreme Court on this aspect.
आज के इस फैसले का आउटकम क्या मानते हैं सर आप? कानून बनने में क्या फायदा हुआ, क्या जोर का झटका लगा या धीरे से लगा, क्या हुआ?
इससे फायदा ये हुआ, जो कुछ एलिमेंट इस तरीके का माहौल ख़राब करना चाहते थे, आज उन पर फुल स्टॉप लग गया है। इस तरीके की जो कई बार जो हमारी कुछ फॉरेन पावर्स जो इंडिया को डेवलप होने से रोकना चाहते थे, हमारी जो सोसाइटी, हमारा जो सिस्टम को ब्रेक डाउन करना चाहते थे, आज उनको बहुत धक्का लगा है और हमारी ट्रेडिशंस कंटिन्यू रहेंगे।
लेकिन ये तो अधिकारों का मामला है, ये कह रहे थे अधिकार, और कोर्ट ये कह रहा है कि भाई इनका अधिकार तो है लेकिन वो अधिकार देने का काम संसद करेगी, हम नहीं।
हाँ, यही इसीलिए जो ये कहते थे कि हम कोर्ट से करा लेंगे, आज उनको पता चल गया है कि हिंदुस्तान की भी कोर्ट जो हमारा जो सिस्टम को चेंज करने के लिए नहीं है, हमारी सुप्रीम कोर्ट भी जो हैं वो ये मानती हैं कि कानून बनाने का, कानून को अमेंड करने का अधिकार भारत की संसद को है आज, और भारत सरकार का भी यही था। तो आज जीत आम जनता की हुई है, क्योंकि पार्लियामेंट जो है आम जनता की है, वहाँ इलेक्टेड आदमी ही जाते हैं और वो कोई भी डिसीजन ले सकते हैं जो वो चाहते हैं।
Sir, there were basically statements made on the adoption if...
All right, that's the word coming in. Now, let's put this verdict once again very categorically and clearly for our viewers. Number one, All judges on the bench, the 5 judges unanimously agreed that there is no fundamental right to marry, which means that there cannot be a mandamus from the court to enforce this right by the way of the petitioners. It is a statutory right, but a statutory right has a lesser degree of constitutional importance compared to a fundamental right. Second, the Special Marriage Act is not void, neither can the words be added into it. Yes, there is a right to form associations, which the same-sex couples have, but that right needs to be enforced by a special committee. The Chief Justice of India, in his learned opinion, has recognized the concept of civil partnerships, but the shape and form is to be decided by the government of the day through the committee. Let's hope that happens. Mr. Sumit Chandar, who's an advocate, is joining us on the broadcast. Sumit ji, it's a setback to the petitioners. They wanted much more to come from the Supreme Court of India. In fact, it seems that the top court on most points has agreed with the government of the day.
Yes, to a great extent. In fact, I would say the Supreme Court has gone in favor of the petitioners. Though, so far as the marriage is concerned, the Supreme Court was very clear that they cannot enter into the domain of making the new laws or making amendments to the Special Marriage Act, which is purely the domain of the Parliament to do so. However, though there is no marriage being allowed under the laws for which the Parliament has to look into, they have given all the rights which come as in a heterosexual marriage relationship, be it the inheritance law or the adoption law. So those are the great changes, great advantages given to the petitioners under this judgment which was passed today.
Point of the CARA guidelines which have been set aside, and the court has very categorically said that even queer couples can adopt as a couple like heterosexual couples can, but in terms of inheritance and various other civil rights that need to be enforced, it's the committee that has to look into, the state governments that have to look into, because marriage is a concurrent subject. I want to bring my colleague Ananya Bhatnagar and Anshul into the discussion. Ananya first, he was tracking all the hearings, all the judgment pronouncement that was happening at the Supreme Court of India. Ananya, are the members of the community dissatisfied? Are they disappointed today after what the Supreme Court has done and has chosen not to do? Ananya Bhatnagar.
Well, definitely the Supreme Court was being expected to do much more. However, the topmost court of the country, in different opinions, have very categorically held that, there is not the right to marry for these people, and the maximum that could be given is that the centre has been asked to actually formulate a committee, take views of the states, and to extend certain benefits to the homosexual couples. And though the Chief Justice of India has recognized a civil union, the other judges on the bench have disagreed with the same. Though Justice Kaul and Justice Chanchud were of the view that civil union should be given a clear recognition, but the people, the members of the bench have very clearly and categorically said that a civil union cannot be recognized. There is no particular fundamental right to get married, is what in fact the most of the judges have very categorically submitted. Though the LGBTQ community people were expecting a lot more from the topmost court of the country,
yes,
but all they could get is a committee that has been formed by the central government that would be going in and in fact looking into the particular issues with regards to extending benefits
Ananya,
of social
you were tracking threadbare all what the judges were saying, what different judges and their pronouncements were. Let's simplify it for our viewers what the judges said on the bench. All 5 judges unanimously agree, Ananya, that there is no fundamental right to marry. I think the major point of disagreement between the judges was that to what extent civil partnerships can be recognized, and that was something that Justice Chandrachud spoke about in his judgment, but at least 3 judges on the bench refrained from giving any kind of even an obiter dicta understanding or recognition to these civil partnerships or union. This is something which is completely left open for the union government to decide. A quick point from Ananya, then I'll go to Anshul.
Well, definitely, this is exactly what the Supreme Court has said. All the 5 judges have concurred on how, a centre would be going in to form a committee. In fact, on the adoption rights also, we see that 2 of the judges have actually disagreed and said that, the CARA circular is something that is very crucial and cannot be held to be violative of the law. But very clearly and categorically, Anusha, this verdict is something that the LGBTQ community might not be satisfied with. It might be, we might see a review petition or some kind of since it's a constitution bench judgment, there might be a larger bench that it should be sought.